In this, our penultimate unit, studying the common law tradition, common law methodology, we are going to explore the process, a methodology, if you will, for reading U.S. case law. Now, as a student of law myself, I always found the process of reading American case law to be somewhat challenging. I'm sure you've all seen our case books. They're huge, they're tomes, and they weigh a ton. And yet we are supposed to prepare these cases prior to class. And again, we spoke about the use of the Socratic method in the classroom and the tension you feel when the professor decides to ask you a question. And so preparing for class is a complex process, and it involves reading these cases. Now, I've always kind of somewhat suspected that the cases chosen to be included in a case book were not always chosen for their legal writing clarity. I suspect that sometimes opinions are chosen certainly for what they bring to the law, but as young first-year law students, it takes us a while to understand how to read the law. And so we struggle. We go through day after day in class not really sure about the process we are engaging in. And as a result, students over time have referred to the classroom experience in first-year law school as a process whereby the professor hides the ball. You're not sure where it is. You've read the same case that she is discussing in class, and yet you're not sure what point she's trying to make or what she wants you to say in response to her questions. And so this process of hiding the ball can be a little intimidating. Ultimately, of course, over time, we learn how to do it. We learn the process. We gradually learn to, as they say, think like a lawyer. And it's a very rewarding feeling when it begins to make sense to us. But for that first year, it's challenging. And understanding how to find the ball takes us some time. Now, in our study of common law here at the University of Navarra, we've used, as I made reference to at the opening of our first unit, we've used the Dernbach text on legal writing and legal method. When I first saw this text, I said to myself, wow, if I'd only had that text when I was a law student, I wouldn't have worried so much about finding the ball. Because chapter 3 of the Dernbach text, which is going to be the principal focus of this unit, provides us with a 9-step methodology for reading U.S. case law. It's very straightforward. It's very practical, it's very hands-on. And in the 8 or so years that we've been using the Dernbach text in our Anglo-American Law Diploma program, our students, well, the reality is it has engendered quite a following on behalf of our students. And our students have said that of all the materials that we've used in the 4 years of the Anglo-American law process, the Dernbach text, and in particular, chapter 3 of the Dernbach text, which we are going to use in the following minutes, was the strongest tool in their new common law toolkit. In reaction to which, and at the risk of horribly mixing our metaphors, I have come to say that if the materials employed in our first year studies in the common law, where a hamburger of the type special sauce, lettuce, cheese, pickles, onions on a sesame seed bun, if the material we've used in this class and its diploma program were a hamburger, Chapter 3 of the Dernbach text would be the meat. Absolutely essential. So that which follows comes from his text, and we will begin with describing what he refers to as the three major difficulties in reading U.S. case law. All of this said, on with the Dernbach method for reading common law case law. Professor Dernbach, as I mentioned a moment ago, identifies for us three major problems in reading common law case law. The first is learning how to think in reverse. I'll explain that a little bit more in a minute. The second problem is understanding the interrelationships of the elements that make up a judicial opinion. And the third challenge, unfortunately, is the reality that not all of the elements that you would expect to appear as part of the opinion, not all of them are always there. So three major elements, three major challenges. One is learning to think in reverse. The second is understanding the interplay between the elements. And the third is the reality that not all of the elements are going to be in the opinion itself. So let's start examining each of these three major challenges in a little bit more detail. The first, thinking in reverse. Thinking in reverse, another way of thinking about thinking in reverse, is the concept of reverse engineering. Reverse engineering is a process of taking something apart to understand how it works. Now, in the late 1940s, 50s, and 60s, Japan, after the Second World War, was going through a process of retooling its industries from wartime to peacetime production. And during that period of time, it reverse engineered a lot of products from around the world. Now, unfortunately, as a result, the industrial mark made in Japan during that time period was not representative of a very high level of quality or product liability, product strength, if you will. But over time, the Japanese perfected this reverse engineering model. And today, the industrial mark made in Japan is indicative of some of the highest quality and the most reliable products the world has to offer. So if it worked for the Japanese, it should work for us. We're going to reverse engineer our cases. So that's the first major challenge. The second major challenge is understanding the interplay between the elements of the case, the holding, the issue, the facts, the rule of law. And the last of the three elements is this reality that not all of these elements are going to be clearly expressed, and at times some of them may be entirely absent from the legal opinion. Now, you may ask the question, why is this the case? Why would some of the elements that one would expect to be central and necessary to a legal opinion, why would they be absent? Well, the reality is, and the somewhat simplistic but very human answer to that question, is simply the fact that not all judges write well. It's a fact, unfortunate as it is. It's a complex job being a judge. And sometimes the opinions are missing a few elements that make them a little difficult to understand, to comprehend. But our process of reverse engineering the case elucidates for us this interplay between the elements. And those elements that are missing may be found, or understood at the very least, by focusing on the elements that are present. The reality is, difficult to read or not, the case is law. And we need to understand how to work with it, and through the concepts of precedence and stare decisis, work with it or avoid it. The bottom line is we need to understand it. And so this 9-step process will help us do that. So let's begin our walk through this case law reading methodology that we get from Mr. Dernbach, Professor Dernbach. Step number one. Step number one, very straightforward and quite simple. Read the case. Now, obviously, you say to yourself, I have to read the case to be able to understand it. But no, the emphasis here is on reading the case multiple times. I will challenge you. I would suggest that you would not be able to fully comprehend a judicial opinion with only one reading. I would suggest that 2 readings are insufficient. So I challenge you to read the case at least 3 times before you begin this analysis. Only through intense, in-depth reading will you come to begin to understand how the court arrived at its decision. So step number 1, read the case. Step 2, identify the holding. Now remember, we're reverse engineering here, all right? We're going to the end of the case and working backwards. But there are 2 problems. Professor Dernbach has indicated to us that holdings, the holding of the case, the decision of the court, can take various forms. In essence, there are 2 forms that we're looking for. The first form is the most readily identifiable, and that's the express holding. There the court will indicate in so many words what it is deciding. We hold that. Driving 60 miles an hour in a 30-mile-an-hour speed zone is prima facie reckless driving. Maybe the holding, maybe the express holding of the case. But sometimes the holding is not so easily identified. Sometimes the holding is implied. The court may give you a decision and the reasons it's based its decision upon, but it may not give you clear language with regards to the rule that is formulated. In such instances, in instances where this holding is implied, we are challenged to identify it. And in instances when you are in doubt with implied holdings or with express holdings, when in doubt, look to what the court actually did rather than what it said it did. There you will identify the result of the case, the outcome, and its holding. So step number 2, identify the holding. Now bear with me here. What was step number 1 again? Step number 1 was read the case. And step number 2 is identify the holding. All right, I want us to develop a mantra here, a mantra that you know so well that you'll actually be able to repeat it in your sleep. So step number 1, read the case. Step number 2, identify the holding. Now step number 3, identify the issue. The issue, as we know, is the question the court has been asked to answer. The issue may be, as the holding, express or implied. An expressed issue is easily identifiable. The court will say, the question in this case is, but as with holdings, frequently the court doesn't clearly express the issue, or the court will tell you the issue is one thing when a close reading of the case indicates that the issue is actually something else. Now, when that happens, when the court says it's one thing, when the a close reading of the case shows you clearly that it's something else, you might ask the question, why? Why would the court say the question is one thing when it's actually another? Well, again, the simple reality is that judges, not all judges, write well. And again, it's a tough job. So sometimes you will have some difficulty identifying the issue. Now, when you have difficulties, identify the issue based on the holding and the reasons supporting the holding. The holding helps identify the issue because the holding is the answer to the issue. The holding is the answer to the question the court has been asked. So when in doubt, look to the holding and the reasons supporting the holding to identify the issue. Step number 3, identify the issue. Let's go back. Let's develop our mantra. Step number 1, read the case. Step number 2, identify the holding. Step number 3, identify the issue. Okay. Step number 4, identify the rule. Step number 4 also happens to be 4 letters long, R-U-L-E. So step number 4, identify the rule. The rule may be a prior case, a synthesis of prior cases, or a statutory provision. The rule can be inferred from the identified issues, holdings, and facts of the case. The rule is the general legal principle relevant to the factual situation presented. Rules, issues, and holdings are all closely related in the case. They have an intimate relationship. And if you have a difficulty identifying one, look to the others to help you identify. The issue is generally how the relevant rule will be applied to the case. The holding is the resolution of the issue, the determination of how the rule should be applied to the case. Stated another way, the holding is the rule modified by the facts of the case. Step number 4, identify the rule. All right, let's try our mantra again. Going back to the beginning. Step number 1, read the case. Step number 2, identify the holding. Step number 3, identify the issue. And step number 4, 4 letters long, identify the rule. Excellent. Step number 5, identify the facts. Also happens to be 5 letters long, F-A-C-T-S. Identify the facts. Now, there are 2 types of facts in court: legally relevant facts and procedurally significant facts. Legally relevant facts are outcome determinative. They are the basis upon which the court reached its decision. Sometimes they are events that did occur. Sometimes they are events that did not occur. And it's impossible to know which facts are legally relevant without first knowing what the court decided. Yet another reason that we start at the end and reverse engineer the case. At other times, you will have to guess the facts, the legally relevant facts, from the court's holdings and reasons. There is no rule that indicates which facts are outcome determinative, and no one single fact is necessarily legally relevant. So those are our legally relevant facts. The second of our 2 types of facts, procedurally significant, describe at what stage in the case an error may have occurred. They are routinely stated. Our procedurally significant facts are routinely stated by the appeals court at the outset of the opinion. So, step number 5, identify the facts. 2 different types of facts: legally relevant facts, procedurally significant facts. So one more time, bear with me. Let's do our mantra. Starting at the beginning. Step number 1, read the case. Step number 2, step number 3, identify the issue. Step number 4, identify the rule. Step number 5, identify the facts. Excellent. Step number 6, identify the disposition of the case. The disposition of the case is simply where in the court system the case is situated. Is it on appeal? Where in the court system is it? What was claimed as error if it's on appeal in the court below? The disposition of the case is simply a statement of what the appellate court did with the decision of the court below. Either it affirmed it, reversed it, or remanded it. Where is the case? What is its disposition? Step 6. So let's do our mantra again. Step number 1, read the case. Step number 2, identify the holding. Step number 3, identify the issue. Step number 4, 4 letters, identify the rule. Step number 5, 5 letters, identify the facts. And step number 6, identify the disposition of the case. Excellent. Step number 7, identify the reasons and the policies. Only through a thorough understanding of the reasons behind a court's decision can we understand what the decision actually means and how broadly or narrowly the decision can be applied. Policies are the underlying reasons and purposes of the legal rules themselves. They are similar to, but broader than reasons. And the easiest way to identify policies is to first identify the holding. Once you've identified the holding, look to the court's social justifications for their decision. Now, sometimes a court will not use or state policy as a grounding or the basis for its legal opinion, especially when the rule and its application are fairly well settled. It's well known. The court may choose not to make reference to the policy because it's understood. This area of the law has been thoroughly litigated, and it doesn't feel the need to repeat the social justifications for its decision. In that instance, if you yourself, as a young lawyer, are not aware of what the policy justifications should be, look to earlier opinions. How do you know which earlier opinions to look to? Look to the opinions that the court itself cites to find expressions of social policy, social justifications that the court relied on, in this case, from previous cases, serving as precedent or stare decisis. Now, the close relationship between reasons and policies sometimes make it difficult to tell them apart. When this is the case, when you are confused, when you are in doubt, recall that the reasons tell you how the court reached this decision. And the policy, the social justifications, tell you the why. Reasons tell you how, policies tell you why. And when these two concepts are clear in your mind, you may see that an opinion can make sense without any policy justifications, but it cannot make sense without any reasons. It can make sense without the why, the policy, but it cannot make sense without the how the court arrived at its decision. So step number 7, identify the reasons and the policies. One more time with our mantra. Step number 1, read the case. Step number 2, identify the holding. Step number 3, identify the issue. Step number 4, identify the rule. Step number 5, identify the facts. Step number 6, identify the disposition of the case. And step number 7, identify the reasons and the policies. Excellent. Step number 8, check for congruency. The issues, rule, facts, holding and reasons and policy all have a close relationship with one another. That should have become apparent to you by now. Together they make up the opinion and they must be congruent. There is an interplay among them that helps us to identify elements that are missing in the opinion. The court's holding will be a combination of the relevant rule of law and the significant facts. The issue is the holding stated in the form of a question. How does this rule of law apply to the particular facts of this case? The answer to the issue, again, will be the holding. Policies and reasons form a basis for the holding, and such an interaction makes the case an interlocking whole and underscores why we cannot understand one element without reference to the others. Always pause when you have gone this far in your case analysis, when you have gone this far in your reverse engineering, to make sure that the elements of the case are congruent with one another. You may do so by creating a graph. In the left-hand column of the graph, you may put your different categories, your different elements, the facts, the rule, the issue, the holding, and the reasons and the policies. And on the other side of this graph, this little box, you may write for the category facts, write what happened. For the category rule, write the rule of law as you've identified it. For the issue, ask yourself the question, does the law apply to these facts? And then for the holding, you're answering the issue. The law does or does not apply to these facts. And then for your reasons and policies, you write the how and the why the law does or does not apply to these facts. So step number 8, check for congruency. Let's do our mantra again. Step number 1, read the case. Step number 2, identify the holding. Step number 3, identify the issue. Step number 4, identify the rule. Step number 5, identify the facts. Step number 6, identify the disposition of the case. Step number 7, identify the reasons and the policies. Step number 8, check for congruency. Check for congruency. Very good. Step number 9, and our last step. In multiple issue cases, identify each of the issues individually. A case can frequently contain more than one issue because there may have been several disagreements about the law that the appellate court was asked to resolve. It's quite common that cases contain multiple issues. It's very seldom that they will be asked one issue. The example we used earlier was the question, is driving 60 miles an hour in a 30-mile-an-hour speed zone prima facie reckless driving? It was the only issue in the case, and the court's holding, the court's answer to that question was yes, driving 60 miles an hour in a 30-mile-an-hour speed zone is prima facie reckless driving. But most often there are multiple issues in a case. Sometimes the appellate court will dispose of the entire case by answering just one issue, by answering just one of the questions that it has been asked to address. But other times, it will entertain multiple issues. And in this step, step number 9, our last step in our 9-step methodology for reading common law case law, when you see that there is more than one issue presented to the court, You must go through the 9-step process of identifying the rule, relevant facts, holding, reasons and policies supporting the court's decision. Because each of these issues, the holding, the answer, if you will, to each of these questions before the court is a rule of law. And in multiple issue cases, we must identify the 9-step process for each of the issues the court addressed. One last time, bear with me. Let's repeat our mantra. Step number 1, read the case. Step number 2, identify the holding. Step number 3,
identify the issue.
Excellent. Step number 4,
Identify the rule.
Step number 5,
Identify facts.
Step number 6,
Identify the disposition of the case.
Step number 7,
Identify the reasons and policies.
Step number 8,
Check for congruency.
and step number 9.
In multiple cases, analyze each issue separately.
Excellent. Thank you all very much.
Professor, during the description of the steps designed to analyze a case, we've talked about rules, policies, and reason. What I see is that every rule contains a policy and a reason. And when reading an ordinary case, how can we distinguish?
An excellent question, because at times it's very difficult to distinguish these elements apart. Quite simply, rules come from case law. They are the holdings of previous decisions, which are the answers to the questions the court in the past has been asked. So the rules come from case law. Policy, in its strongest and clearest form, is legislative. It's coming either from the state legislature, and we recall, of course, that the states came first, okay? Coming from either the state legislature or the national legislature. Now, under Article 6 of the U.S. Constitution, the national law is the supreme law of the land. And so where the federal Congress has legislated, the states may not legislate, may not develop policy, if you will, contrary to that policy. But we must always remember that we have legislatures at both the state and the federal level. So policy can come from a number of different sources. It can come from the state legislature, can come from the federal legislature, it could also come from the administrative regulations that are the product of statutory law. And the example I used in our unit was the Food and Drug Administration. So policy, and again, this harkens back to Unit 1, where we defined the law in the common law tradition. And we defined the law in the common law tradition, again, as the rules and social policy that regulate behavior in society. And this term regulate implies law. So what we're really talking about is statutory law in the U.S. legal system. And again, statutory at the state level, statutory law at the federal level. Now, reasons. Reasons are the how of an opinion. Policy is the why. So how do we distinguish between the hows and the whys? Well, reasons are the logical process that the court has stepped through in arriving at its decision. And as we said in our earlier unit, an opinion can make sense without policy justifications, but it cannot make sense without the reasons. It cannot make sense without an explication as to how the court arrived at its decision. So the hows, reasons, the whys, policy, subtle differences between the two. But policy really is social justification. And when you hear the court speaking about society and the rationale employed that embraces social interests, we truly are speaking of policy rather than reason. Excellent question. Thank you.